Hi everyone, let's talk about capacity and legality. Contractual capacity is the legal ability for somebody to enter into a contract. So we're going to look at that and look at the things that can break down contractual capacity. The law presumes that parties involved in a contract have contractual capacity, and the bulk of this chapter is breaking down, well, in what situations would somebody not have that capacity. The main reasons would be a person who is a minor, a person who is insane, a person who is intoxicated. So we'll sort of talk about the ins and outs of those categories. We'll also, after capacity, look at certain types of contracts that are illegal and the effect that that would have on the parties involved. So a minor is a person who has not reached the age of majority. The age of majority will be defined by your state. In the majority of states, a person of the age of majority is 18 years old. And keep in mind that this is specifically talking about contractual capacity, the ability for somebody to enter into and be bound by a contract. There are lots of other age limits that states and the federal government put on people. When you can drive a car, when you can buy cigarettes, when you can drink alcohol, stuff like that. This is specific to contracts when we talk about the age of majority. We presume that a person under the age of majority doesn't have the maturity, experience, or sophistication needed to enter in a contract, so we give them some protection, saying that if you sign a contract, you have the ability to back out of that. And that's the protection we give young people until you turn 18, and then we think you have the ability to, whether or not somebody really does. It goes by individual, but 18 is the law. The infancy doctrine is the doctrine that allows minors to back out of contracts. We call that backing out of a contract, disaffirmance. A minor can disaffirm a contract. The contract is voidable by the minor, giving them the option to back out. So the reason it's a bad idea to contract with a minor is because they have the option to disaffirm that contract. You, as the competent adult party, don't have that right. And if the minor wanted to stay in the contract and enforce it against you, you would have no choice but to perform. The duties of restoration and restitution apply. If a minor disaffirms a contract, they only have the obligation to return the goods or property in the condition it is in at the time of their disaffirmance. The duty of restitution means that I have to give money back to the minor, putting them in status quo. In this situation, status quo means I would have to place them in a position they were in before they entered into the contract. So even if I transferred property to a minor and they gave me money, and let's say later on they want to back out and return my property and get their money back, I'd have to give them their money back and they'd give me my property back. Even if that property had been damaged, I might not be able to deduct any money from that. And that's just the protection that we give minors. There are some situations in which I could deduct for damage. It's going to ultimately be up to the court. But the basic idea is they can disaffirm and return the property in whatever condition it's in. Let's say I sign a contract when I'm a minor and then I turn 18. I can ratify a contract, meaning that I indicate that I'm willing to be bound by that contract. I can ratify by saying it to the person. I can write it down, or I can imply it by my conduct. Some contracts a child would enter into actually become the parent's liability. So one of the responsibilities a parent has toward their kid is to provide for the necessaries of life. Necessaries of life we define as being food, clothing, shelter, transportation sometimes, the things that it just takes to survive in modern society. And so if I kick a kid out of my house and they have to go buy food and clothing and find a place to live and all this stuff, and let's say they don't have the money to actually pay those people back, that might become my responsibility as the parent to pay off those debts. My parental liability and my responsibility toward them would terminate if a minor becomes emancipated. Emancipation is the process of a minor voluntarily leaving home and living apart from his or her parents. This happens sometimes if a child is living in an abusive environment or an environment that's just not safe for them in some other way. You'd have to go to a court and get the court to agree that it'd be better for you to be on your own rather than living with your parents. And if you become emancipated by the court's order, then you're considered to be an adult and have the right to make informed and be bound to contracts, just like any other adult 18 years of age or older. One kind of contract that a minor, even if they haven't been emancipated, a type of contract that a minor can enter into and be bound to is for buying necessaries of life, like the example I gave earlier, where it could be the parent's liability. Kids can also go and buy food, clothing, shelter, and sometimes some types of medical care, things that are necessary for the maintenance of their life, and be bound to those. Looking at North Carolina specifically, and I'll post this PowerPoint in Blackboard so you can look at my links. But we have specific laws that cover certain areas. So minors can buy car insurance if they're a ward of the state are in custody of social services. They're allowed to buy car insurance. We have a specific law regarding child actors and artists to sign contracts with talent agencies. There are some legal and financial safeguards. The court will appoint a guardian ad litem that will look after their legal affairs, and it establishes some financial safeguards in the form of establishing a trust and putting a percentage of their earnings into that trust that can only be used for the child's benefit. But, with those safeguards in place, and as long as the court approves of the contract, then a minor can be bound to it, even if they're very young. If you're 17 years old, there's a couple things you can do. You can be bound to a student loan contract. If you just graduated high school, you're getting ready to go to college, you sign up for those student loans. A lot of people aren't 18 yet when they graduate high school. So if you're 17, you can be bound to those. You can also enlist in the military at 17. You have to have parental consent, but you can do it. Some minors are allowed to marry. Generally you should be 18, but kids who are 16 to 17 can get married as long as they have parental consent. And there are very rare instances in which a girl who's 14 or 15 could get married. You can click on that link to see North Carolina's laws about it. The effect that marriage would have on a minor is that they become emancipated and when they'd have all the rights to form contracts like an adult would. We have a specific law for obtaining healthcare services. And a kid, when starting at the age of 16, can petition the court for emancipation. So when you're 16 or 17, you can try that if you're living in a bad situation and think the court should let you live on your own. Switching gears a little bit, we look at mentally incompetent persons. So the law is going to have some protections in place for people suffering from substantial mental incapacity, protecting them from enforcement of contracts. I would have to be legally insane at the time of entering the contract. In other words, I don't have the mental capacity to understand the nature of the contract and what it means to be bound by it. Let's look a little bit more at that. There's two ways that I could be adjudged insane, meaning there's some competent authority, a court or an administrative agency that declares me legally insane, and I have that declaration on record. Forming a contract with somebody who's been adjudged insane is void, having no effect at all. And the court will appoint a guardian who can contract on their behalf. So the court basically appoints a person, could be an attorney or a family member or somebody, who would be in charge of all my legal affairs, and they would make informed contracts on my behalf. They basically have control over that insane person's entire life. There's actually a really cool show on Netflix right now called Dirty Money, and there's an episode on guardianship that follows some people who had been taking advantage of this system, trying to get guardianship over some elderly people, have them adjudged insane, and then basically plunder all their wealth. So that would be an example of somebody abusing that system. But in general, the system's set up to actually protect people. I could also have the court decide that I was insane, but I hadn't been adjudged insane. In that case, it just means that, looking at the circumstances, it's clear that this person was actually insane, even though they didn't have the declaration from the court. In that case, the contract is considered to be voidable by the insane person, meaning they have the ability to back out of it, but the competent party generally would not. If we void the contract, the competent party has to place the insane person in status quo, meaning put them back in the position they were before the contract. If the competent person was unaware of the insanity, most states hold that the competent party has to be placed back into status quo. Some people, maybe when you're in the early stages of Alzheimer's or something like that, have periods of lucidity where they are back to their normal selves and are clearly aware of what's going on. And if they make a contract during a lucid period, we could find that that contract is actually valid. Insane persons are liable in quasi-contract to pay reasonable value for the necessaries of life they receive. So even if we find the person's insane, if we found out that they were just buying food, clothing, shelter, stuff like that, then we can actually bind them to that. This case involved a woman named Patricia Watson who had a substantial amount of assets, over $1 million worth of property and money. And she, in her retirement, about the age of 70, married a slightly younger guy at the age of 60 who didn't really have a whole lot. She'd started to complain about some memory loss and went to some doctors who diagnosed her with Alzheimer's disease. And subsequent to that, we find that she signed a bunch of paperwork transferring a bunch of property over to her new husband. Before this, it was her half siblings, the Ivies, who stood to inherit all of her property. And it was all signed over to Smith, who was her new husband. After Patricia Watson's death, Smith took possession of all this property that had been signed over to him, but the Ivies sued, saying that she didn't have the contractual capacity at the time she signed over all that property to Smith. And they wanted the court to set that aside, void all those contracts, and actually distribute that property to the Ivies instead, which is exactly what the court did. Key in the case is having a doctor's opinion and diagnosis that she did have dementia, which would be really good evidence that she lacked that contractual capacity. A person who is intoxicated could also lack contractual capacity. If you go out to a bar and have a couple drinks and, form some kind of business agreement, I would have to prove that I was so intoxicated that I was unable to understand or comprehend the nature of the transaction. That can be really kind of a point of controversy if it actually lands in court. How many drinks did a person have? Over what period of time? Did they have anything to eat? How much does that person weigh? It's best to just not form contracts when you're having drinks, or at least if you intend to be sincere about that, call the next day to confirm while both parties are sober, just to verify that we both meant it. A lawful contract is one that has a lawful object, as the name would suggest. So an illegal contract is one that has an illegal object. These contracts are considered to be void. In this case, Ford Motor Company had a contract with Grewati Auto, which is a Syrian auto manufacturer. And the idea was that Ford would establish a dealership network in Syria to start making and selling Ford automobiles in Syria. After they formed this contract, the President of the United States issued an executive order imposing a lot of sanctions on Syria. And so Ford goes to the court and seeks to have an acknowledgement that they're no longer bound to this contract because it was contrary to law. Now, it wasn't when they formed it, but now it is. And that's what the court did. Grewati Auto sued, saying that there was a breach of the contract, and thus Ford owed them money. But the court said that, well, at the time it was a legal contract, but after the executive order, then it would have been illegal for Ford to perform, so the court was not going to bind them to that contract. Usury is, I don't know if you guys have heard the word usury before. The basic idea is usury is charging an interest rate that's too high. And so a lot of states have laws on the books establishing a maximum interest rate that can be charged on certain types of loans. And I think in North Carolina, for a lot of loans, we set the usury rate at 8%. And it didn't really mean a whole lot because there's so many kinds of loans that I can get where the interest rate would be higher. But the basic idea is that we establish an upper, a ceiling on interest rates. I'm not aware of a whole lot of cases where somebody's bringing a usury case, but it's something to be aware of if I'm in the business of loaning money to people, to make sure I'm not violating a state statute on usury. This seems pretty intuitive, but if I form a contract to commit a criminal act, that would be considered a void contract. The court is not going to step in and try to enforce that. If somebody breaches and I'm trying to enforce that contract against somebody, they're probably not going to deal with me. And depending on the extent to which I admit criminal actions, I might just get myself in a whole lot of trouble. A lot of states also have gambling statutes. I would say most states have gambling statutes on the books. Gambling is really only fully legal in a handful of states, although we do see some exceptions. But, North Carolina is no exception. We have laws on the books saying that gambling is illegal in most forms. It was a big deal when we passed the North Carolina lottery. That was a pretty big deal several years ago. The big rage now is the possibility of a casino being built in Kings Mountain, which would be a pretty big change for our area. But forming a contract to gamble would be a void contract, illegal, having no legal effect. I thought this was just a really interesting case. It happened in Connecticut, not North Carolina, but it was just a really fun story for me. A couple of 80-year-old sisters had for years been going to a casino and buying lottery tickets and doing all this stuff together, to the point where they actually went to an attorney's office and drew up an agreement saying that if one of them won the lottery, or just won any kind of money, that they would split the money among them, among the two ladies. However, after they got this agreement signed, their relationship deteriorated pretty dramatically. And there was, the facts are a little bit in debate, but there was actually a phone call where they seemed to call the agreement off. It wasn't written, but they kind of had a phone conversation about it. So later on, Rose, one of the sisters, wins $500,000 in a lottery jackpot. And rather than splitting it with her sister Teresa, she split it with her brother Joe. So Teresa sues for breach of contract, saying they had this splitting contract and that she owes her half of the money. The first court actually agrees with Rose because their defense was that it was a wagering agreement and shouldn't be held to be valid in the state of Connecticut. The appellate court reverses and says the contract was not actually a wagering agreement within the definition of the state's statute. It goes to the Connecticut Supreme Court, who affirms what the appellate court said, and then they throw it back down for a full trial. So in the lower court, at the trial, the court decides in favor of Rose on different grounds, saying that even though the contract was valid at the time, they had rescinded the contract in that phone call. So the sister should no longer be bound to that contract. It had been rescinded and is no longer good. And on those grounds, they decided in favor of Rose, and Teresa didn't get anything. So the common law rule regarding the effect of illegality on a contract is that the courts will refuse to enforce or rescind an illegal contract and will leave the parties exactly where it finds them. In other words, the court's not going to do anything. But like with many legal rules, there are exceptions. cases in which an innocent party in an illegal contract might be able to sue to recover some money they paid, for example. One of the exceptions is when an innocent person who was justifiably ignorant of the law or fact that made the contract illegal. If I just had a really good reason for not knowing why the contract was illegal, I might be able to recover some money that I paid. If I had been induced to enter into an illegal contract through fraud, duress, or undue influence, I might be able to recover. If I entered into an illegal contract but withdrew before the illegal act is performed, I might be able to recover. And then there are cases in which a person who is less at fault than the other party might be able to recover. And so we introduce a legal concept called in pari delicto, which translates into in equal fault. So the idea is if the court finds that both parties are in equal fault, it's not going to go in and do anything redistributing losses among people who are wrongdoers. But a lot of states allow for relaxation of this rule, saying that the less guilty party can actually recover under an illegal contract if I can prove that I was the one that was less at fault. Contracts contrary to public policy won't be enforced. There's not a very precise definition of public policy. The general idea is that public policy is things that deal with public safety and welfare. So if we have a contract that has a negative impact on society or that interferes with public safety and welfare, then the court will not enforce that contract. Some of these are, I guess an example would be immoral contracts where it might not be specifically illegal, but a court would later find that the actions were immoral. This won't happen a whole lot because it's not necessarily up to the courts to decide what is and is not moral, but it is a possibility. So we'll deal here with some special types of contracts and some licensing statutes. If a court finds that a contract is in restraint of trade, it's not going to enforce it. This is relatively rare to see a case like this, but if two companies were conspiring to fix prices or create a monopoly, something behind the scenes that we have statutes against this type of thing, something that would unreasonably restrain trade, then the court won't enforce it, and the companies could actually get in a lot of trouble for forming these kind of contracts. Sometimes a person has to be licensed in order to run a business or to perform a certain type of service, and whether or not a contract will be enforceable depends on whether or not the licensing statute was for regulatory reasons or just for revenue-raising reasons. If we decide that the licensing statute is regulatory, then a person who is unlicensed who performs some act under contract wouldn't be able to enforce the contract. Like if my doctor, by law, for regulatory reasons, has to be licensed to perform medicine, and if they perform some procedure and try to bill me, but I find out they actually weren't licensed, then they wouldn't be able to recover that money from me. However, if we find that it's just a revenue-raising statute, the whole purpose isn't for public safety, but just to raise revenue for the government, then a person performing services who we later find is unlicensed can still enforce that contract. An exculpatory clause is a common part of contracts where there might be something dangerous involved. If I'm going skiing, skydiving, bungee jumping, roller skating, pretty much anything where there's any kind of danger of somebody getting hurt in some way. That's an example of an exculpatory clause. There are a lot of other examples, but the basic idea is that we acknowledge in the contract that if something goes wrong here, I'm not going to hold the person liable, not going to hold the business owner liable, usually is the form that it takes. It's not always going to be bulletproof. I sign an agreement not to sue somebody if I fall down and break my leg skiing. And if it was my fault, then I'm not going to be able to sue. Even if it was the ski resort's fault, they still might be able to enforce that exculpatory clause against me. They wouldn't be able to defend if it was a willful act, if there was fraud involved, if they were just completely reckless, or if they were grossly negligent, but it will provide a good amount of protection for the business owner not to be sued. In this case, a lady went and, DeCormier, went and bought a Harley-Davidson motorcycle, and she went out on the test track that they have outside the dealership, and was just going to give it a couple of rides around just to sort of get used to driving a Harley-Davidson. And it was a little bit wet and slippery that day, and she, the bike slid out from under her and actually caused significant injuries to her leg. So she sues, saying it was negligence on the part of Harley-Davidson to let her drive out there when it was wet and slippery. So it was their fault, so she should get a lot of money out of this. We find out she signed an agreement prior to driving that had an exculpatory clause in it, saying that, if something happens, you have to acknowledge that there is substantial risk of bodily injury here, and you're not going to hold Harley-Davidson liable. So they used that exculpatory clause to defend against her claim, and the court agreed, saying she signed the agreement and she can't sue. We've talked about covenants not to compete quite a bit in this class. I think at this point, a special type of contract, saying if I'm selling a business or if I'm an employee and I sign a covenant not to compete, also called non-competes, then I won't engage in a similar business for a specific amount of time within a specific geographical area. And in North Carolina, these are perfectly valid and enforceable as long as we're reasonable with regard to the geographic distance, the time involved, the type of work or business involved. And as long as we're reasonable, then the court will probably enforce it. If a contract is so unfair or unjust that it shocks the conscience of the court, they might declare it to be unconscionable and not enforce the contract. It's rare, but it can happen. So to establish unconscionability, we would have to show that the parties possessed severely unequal bargaining power. We'd have to show that the dominant party unreasonably used its unequal bargaining power to obtain oppressive or manifestly unfair contract terms, and that the adhering party had no reasonable alternative but to sign. So, relatively rare, but we do see some examples. There were a number of arbitration agreements several years ago that were determined to be unconscionable just because it costs so much money for somebody to bring an arbitration claim. So we see it happen. It's just not very common. If a court does declare an agreement to be, or even just a clause in a contract to be unconscionable, they can refuse to enforce the entire contract. They might refuse to enforce only the unconscionable clause and enforce the rest of the contract, or they might just look at the clause and, rather than refusing to enforce the entire thing, maybe limit its applicability just to avoid an unconscionable result. So that's capacity and legality.